case. Anything else you wish to share with me, Counsel?
No, Your Honor.
How about from the defense? Anything else?
A commentary on the case that was just provided.
Yep.
I think the polite case, the very first head note, says that the admission of past recollection recorded under exception to the hearsay rule requires the witness to indicate that the statement was made at the time when the events were fresh in her mind, his or her mind.
That's done.
And also attest to the accuracy of the memorandum or record. The opposite of that was done.
Excuse me. And that's in the bottom as well. That you're reading the head note.
Yes.
I just highlighted the portion at the end. It says, we reject the 5th District's embrace of a totality of the circumstances test and affirm that in Florida, the admission of past recollection recorded under Section 98.803, subsection 5, requires that the witness indicate that the statement was made at the time when the events were fresh in his or her mind, and also attest to the accuracy of the memorandum or record. Then it goes on in conclusion. In this case, a proper foundation for admission of the witness' statement of past recollection recorded was not established. As we've explained above, the hearsay statement was inadmissible because the witness did not vouch for its accuracy or correctness.
I have nothing further.
Counsel, my thought is this. If what I heard her say previously was that she couldn't vouch for its accuracy or something to that effect, if that's what she continues with, I'm not going to allow you to admit the evidence. All right?
Understood.
So, are you ready to proceed?
Yes.
All right, let's bring the jury. You're ready as well? Defense, you ready as well?
Yes.
All right, bring the jury.
Presume her.
Yep. Bring the witness in, bring the jury in.
Grab the witness. While we wait, can you go sidebar briefly?
Yep.
re-entering.
Ladies and gentlemen, thank you. Please be seated. Let the record reflect the presence of Jamell Demons as counsel, the Chief State Attorneys, the General Jury, our witness, Bishop Holmes remains on the stand. Ladies and gentlemen, I apologize for the delay. It's my fault. In any event, I think we're ready to proceed now. Ms. Holmes, I just remind you you're under oath. All right. Thank you. Proceed, counsel.
Okay, Ms. Holmes, I want to talk a little bit about your deposition.
Yes.
Do you recall, and you've been provided a copy of that deposition?
Yes, I got, my lawyer got provided a copy.
When you, in that deposition, were you asked if your prior
Objection.
statement...
Improper impeachment.
I heard it over. You can ask your question, counsel.
Ms. Holmes, prior to that deposition starting, were you given your prior statement to review?
What you mean?
Were you?
I understand. The deposition that I did on December 22nd? Yes,
Yes.
it was given to my lawyer yesterday, right before,
Okay.
briefly to look at, yes.
Okay. So the deposition you have, that was
It was
provided
given
to
to my
your
lawyer
attorney
yesterday, yes it was.
Okay. So, do you remember coming into that deposition?
Yes, I do. I was in jail, put me in jail. Yes,
Correct.
I remember.
And
Never
so,
forget.
so it's clear in terms of you don't want to be here.
You're making me be here. Yes, I have
Yes.
a house, a band on my leg. I'm a nurse. I can't even work properly. Yes.
Yes. You were under house arrest because you failed to comply with the
Objection.
subpoena?
No, you did not serve
Excuse me,
me.
sustain. Listen, how we're going to do this is you ask your questions, counsel, ma'am, listen to her question, answer her question.
Yes, I
All
am.
right?
Yes, sir.
Thank you.
Okay. So going back to the deposition.
Yes.
On December 14th of 2022.
Yes.
Do you remember coming to my office?
Yes, I do.
Okay. Do you remember being asked questions at that time?
Yes, I do.
Do you recall being given a copy of your prior statement of December 12th, 2018?
No, I don't remember that. I don't remember thinking, but I'm pretty sure. I
Yeah.
did.
Okay, so what I'm going to do is permission to approach her on it,
With what, counsel?
her deposition.
Objection, Your Honor.
I have to give her an opportunity to.
I saw my
Excuse me, there's no question pending review. All right, you can proceed, counsel.
Okay. So, counsel, I'm showing her page 10, line 10 through 17. Okay, so just read them silently to yourself. So back on December 14th of 2022, were you asked if you need to make any corrections or deletions to the statement of December of 2018?
That's what the deposition said, judicially.
And did you indicate that there was no corrections or deletions in those statements?
I don't remember, but that's what's on the deposition.
Okay. So, December of 2022, you said that this was a correct statement.
Objection.
Objection.
Sustain.
So, Ms. Holmes, is the December 2018 statement that you gave correct and honest?
Objection. Asked and answered.
Excuse me. You have to let, I understand you're trying to answer the question, Ms. Holmes, but when they raise an objection, you
Sure.
have to let me answer the objection first. all
Yes,
right?
sir.
Objection notice overruled. Question is the statement, can you repeat your question?
Is this December 2018 statement correct and honest?
I don't remember the December 2018 statement.
In December of 2022,
Yes, ma'am.
did you state that it was an honest and correct statement?
That's what you put in the deposition. I don't remember saying it, so I can't remember verbatim what happened that day. I remember some parts of this deposition, but not all.
Okay, is there anything that you need to refresh your recollection to determine whether or not I'm being truthful and accurate as to what the question was in your answer?
I don't know to say that.
Okay.
Is that a question?
I've asked if there's anything that
Excuse
was...
me, one at a time. All right? Just one at a time. Let her finish her answer before you ask the next question.
So, Ms. Holmes, is there anything that would help refresh your recollection?
I don't think so. I don't know.
Would the audio of the statement of December 2018 help you?
Objection.
What's the objection?
It's irrelevant. She testified 3 times.
Excuse me, thank you. Not as to this, go ahead, overrule.
I don't know. I don't.
So, Ms. Holmes, with regards to the events of October 26th of 2018,
Yes, ma'am.
did you travel down here to Borough?
Yes, I did.
Who did you come with?
My daughter, Mariah.
Okay, where did you go?
We went to one of Jamell's friend's house.
And whose house was that?
Frida.
Okay. And now approaching what's been previously shown to defense counsel and marked as states triple N for identification purposes only. Ms. Holmes, do you recognize the 2 individuals in that photograph?
Yes, I do.
How do you recognize them?
I know Frida from being on Instagram from rapping. He's a rapper.
Okay, any other individual in that photograph?
My daughter's boyfriend.
Okay.
I'm sorry, I apologize, I didn't hear that.
I'm sorry.
I didn't hear your answer. Could you
Which
repeat?
one? Do I recognize?
Thank you.
I do recognize Frida from Instagram for being a rapper, and I recognize Jamell from dating my daughter.
Your Honor, at this time, state we request to move states triple N in as the next number of exhibit.
Any objection?
Relevance.
Overruled. It'll be admitted.
States triple N, be marked states 62.
This is the photo that you can see on your screen that you just identified? Okay. So when you said Frito, is this the individual's house you went to?
Yeah.
Okay. Ms. Holmes, how much money has the defendant's manager given you since the October of 2018?
Objection. Relevance.
Why don't you come sidewalk?
how much money have you gotten from the defendant, Jamell Demons' manager?
None.
And with regards to that specific statement? Ms. Holmes, you formerly had a credit union account?
Yes, I do launch credit union
Okay. And at Launch Credit Union, you banked there for a number of years?
many years.
The credit union that you've been at, it's been your account, and I won't put your account number on the record for that reason.
Can I object to this line of questioning based on the court's ruling?
Objection, no, it's overruled. Proceed.
So your testimony is that you have never been given money whatsoever?
I've never been given money for personal use.
Okay. So the question is, how much money have you been given by the defendants?
For a vacation for all of us, for him, his wife, and me to pay for it, as far as he gave me $5,000 for Airbnb, which I gave him $1,000 to deposit that.
Okay. So he did give you money?
Not for personal use.
Okay.
Excuse me, can we clarify who he is,
Objection, Your Honor.
Jameson Francois?
Objection, no, just clarify, counsel.
Sure. So it's clear, who is Jamison Francois?
He's trapped, he's Nelly's manager.
And you mentioned his wife as well. Who's his wife?
I used to know her by AA.
So AA and his wife.
We were all good friends.
So I'm going to go through now what's been previously shown to defense counsel and marked as states triple M. It's a composite of 17 pages. Did you have an opportunity to review that prior to coming into court today?
Yes, I did.
Okay. And in terms of the individuals and the phone numbers that are on that, do you recognize your own phone number?
No, I do not.
Okay. Going forward through the contents of that particular item, do you recognize a conversation about a snake?
No, I do not. I know they had a snake, but I don't recognize this conversation.
Okay. With regards to the conversation about the snake that you do remember, what do you remember about the snake?
That they had a snake.
What happened to it?
Objection, relevancy.
Sustained.
Aaron, may we approach that?
Sure.
So, Ms. Holmes, I want to ask you a question as to what was your daughter's phone number back in October of 2018?
I have no idea, I don't know.
Is there anything that would refresh your recollection as to what her phone number was?
No, because I don't remember mine.
You don't even remember your own?
Yeah, no, I don't.
In terms of, did you review your statement of December 18th of 2018? Did you review that statement prior to testifying today?
Yes, I did.
And in that statement, were you asked, what is your daughter's phone number?
Objection.
Overruled.
I don't remember.
If I were to show you the statement, would that help refresh your recollection as to whether or not you were asked that question?
I don't think you would, no. But you can show it to me.
You have permission to approach?
Yes, ma'am.
Okay. 3 of 8. If you could just read silently to your son. Okay. Looking at that, does that refresh your recollection as to what your daughter's phone number
I
was?
still don't recognize the number. It doesn't for me, but I don't know if that's her number. I don't recognize the number.
Okay, so you don't recognize the number.
I got 3 daughters, so I don't know. I don't recognize the
Understood
number.
on that one. So, Judge, permission to treat the witness as hostile?
Objection.
Want you to sidebar, please? I need some time with the attorneys. Please, as you go to jury, do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence and certainly no research. There's leaving no paper on your jury. Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant. Witnesses on the stand. Ms. Holmes, my understanding from counsel's side is that you have an attorney here with you. Is that right?
Yes, I did.
No,
And,
I was told to bring him in here.
It might be a good time for you to talk to him. So, if you want to speak to your attorney, any objection to that? by the way?
Yes,
What's
yes,
the
Your Honor.
objection?
The witness is on the stand, and for the state to suggest to a witness who has already been sworn and is in the middle of testimony that she goes and talks to her lawyer, it's type of intimidation and coercion. I think the rules have been. So we do object to that. It's intimidation.
Well, let me ask you this. Is it something you think you need to talk to your lawyer about?
I'll talk to her. I don't think I need to, but I don't know what the problem is. I'm answering her question like she wants. I'm not sure what's going on.
Well, so my question to you is, do you want to talk to your lawyer?
Yes, I will talk to her.
All right, so we're going to be in recess. You talk to your lawyer, and you go ahead. You step outside, all right?
Okay.
And I'm going to continue with the argument here with the attorneys. So I guess this is the concern I have. You're asking me to declare her a hostile witness. It appears to me she is. I don't know if that's what your position on it. She's at, that would allow her to ask these leading questions as she suggested at sidebar. The problem with any of the questions, though, I don't want you to be asking specific questions that things that she said previously she doesn't remember, and that you're just going to go ahead and put testimony before the jury. I mean, that's, you know, it's not the attorney's questions that are in evidence. I mean, if she doesn't acknowledge it, or even after asking leading questions, she's basically saying, you know, she doesn't know, or that's the end of it. I mean, you can't go much further than that. You can't put in evidence. Didn't you say X, Y, and Z? The police officer, she's not acknowledging she said it. I can't see, you know, how you do that. You can't.
So, Your Honor, I think I can ask the questions because
What question?
in terms of, did you provide this phone number as the number for your daughter? Did you provide this number for the phone number regarding Mr. Demons? Did you provide this information?
What information?
Whatever the particular statement may be that we're at that point in the questioning. For example, did you provide the phone and say that previously that you talked on FaceTime with the defendant? That you talked to him on the FaceTime on the 772-713-9807 phone number. So judges, in terms of if I'm going to then impeach her with some other outside statement or some other prior consistent statement that she has made at some other proceeding at that point, that's the concern as to her perjuring herself on that. So I think that's why it's important that she be allowed to speak to her attorney on that issue. And in terms of the prior statement on that, I still maintain that she has endorsed its authenticity and accuracy. Your Honor was provided with a copy of that deposition that the state referenced when we were talking about, and she indicated she was honest and truthful in that deposition, and she then endorsed the prior statement. So the prior statement should be allowed in on that, and if there's no concern as to any improper or anything on the jurors, because they will be instructed, as they always are, that no statements by the attorneys are evidence.
You wish to be heard?
Yes, please. Your Honor, first of all, the state is now conflating issues. What we objected to and alerted the court to because we knew that this debacle was going to take place, I think it is evident that, yes, it appears as though the witness is not a major fan of the state. That's true. The state knew that going in. This is no surprise. These cases use the very language, surprise. In other words, what the state intended to do under a ruse at 803, 90.803 Section 5 ruse is put on the witness to impeach that witness for that sole purpose of impeaching the witness, to introduce an out-of-court statement that is inadmissible because the state understood that she recanted. The state, under the pretext, oh, we don't know that she's hostile, we just think her recollection is failing, and we believe under 90.803 subsection 5, we can just read her statement in. Unfortunately for the state, the Supreme Court has made it extremely clear that that witness has to vouch for the accuracy of the statement at the time it was made. And the Supreme Court also said in that context that in the context of an 803.5 exception, the contents of the record substitutes for the witness's testimony. This means that the reliability of the assertions rests upon the veracity of a witness who is present and testifying. The state is calling into question her veracity and calling her pretty much a liar, saying that she's feigning recollection and now attempting to essentially introduce a report of a police statement into evidence by the state testifying, asking the court to let the jury know that all this stuff that we're about to say, upon which we want to rest our case, is don't take it from me because I'm just a lawyer saying it, but then there's no point in saying it because there's no way to get it through this witness. She can't put her on to impeach, which is exactly what she's trying to do. The 803.5 is a ruse, and that's not working out, and now she's doubling back to the original, which is let me call her hostile so that I can lead, and instead of eliciting the testimony from her, I'm going to read it out of this report and say, didn't you say that? So what happens is we're going to now be in a situation where she's asking the state to tell the jury, hey, what the lawyers say is not evidence. So it doesn't matter that this witness is going to say, I do not remember that number that you just read to me. That you just let me see. I told you I don't remember it. So I now the state wants to come back to the podium and blurt that number out. She just said she doesn't recall it. So what's the point of saying it other than to introduce it into the record through the state attorney's lips? So rules don't allow her to do what she's trying to do.
Thank you.
So you're in further support of treating a witness as a hostile witness. This has previously been provided to defense, but this is the Instagram production for Miss Felicia Holmes that I'm showing the court now that she is previously identified as her specific Instagram, and that it is saying the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies. They didn't want us talking with prosecutors, but now they have all disappeared. I quit my job based on what Track and his wife or company said. Now look, we can't go home. We're spending all my money I worked for and they taking trips and enjoying life. If you think I was a beast before, wait until this trial. I'm not holding anything back. I'm doing what I should have done in the beginning. They can call me Miss Snitch Bitch. So Judge, it's very clear from this record that my intention and what the witness has represented to me in all shapes and forms that she was going to be honest and truthful. So to say that it's improper for calling her just for the purposes of impeachment is incorrect. So to continue on in that same Instagram production, and this is in June of 2022, Felicia Holmes is saying, they made me quit. Told me that they would take care of us until trial was over. But guess what? Lies as usual. I was making $9,000 weekly. I didn't need shit from them, but everyone begging and pleading. Now they all ghost. I got something for Track though. He lied to me and my child for the last time. Again, saying you're going to air him out to the prosecutor. So Judge, in terms of, so that's in defense of the representation of counsel that is just being called for impeachment. It's also clear that this witness has received multiple benefits from the defendant based on her own statements there, that she has endorsed that that was her Instagram on that.
So, counsel, there's a couple things going on here. Number one is you indicated that it was the testimony was going to be admitted because it was in essence, I forget the statute number.
9803 sub 5, it's a past recollection recorded.
Past recollection recorded, and you
Correct.
gave me the polite case.
Yes.
And that indicates that you have to have a proper foundation, but it has to be not only there's a proper foundation, but it has to, the hearsay statement was inadmissible in that case because the witness did not vouch for its accuracy or correctness, which is what we have here. The witness isn't vouching for the correctness or accuracy of the statement. So it doesn't meet that criteria. On the other issue about impeachment, this is not what she said. She said gave me a different answer. What I tried to read before was something from a couple of cases, and again, the synopsis at the end of it. This is I'm just reading again from the SL, a child case, v. State 993 Southern 2nd 1108. It just says the Florida Rules of Evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at the trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. It goes on and says, interpreting this position, the Supreme Court of Florida recognized that a statement given during a police investigation is not a statement given at and other proceeding. So, then if you agree, I don't know where we're going with this, counsel, respectfully. It seems to me under either scenario, that statement doesn't come in. Now, I do have a message from Mr. Bears, B-E-R-E-S. He says he's Ms. Holmes' attorney. He would like to speak with me. I don't know what he wants to talk with me about. To be candidly, I'm assuming it's this testimony. But anything he could say, he can say right here in open court. I don't have an issue with that.
That's fine, Your Honor. I really question the purpose in advising my client, Ms. Holmes, to consult me for a lawyer. I take that as an implicit threat to Ms. Holmes. We have an agreement that she comes in here today to testify. She's done that. She's honored her agreement. And, she's answered all the questions put to her. She may not be answering the questions to the satisfaction of the state, but she has fulfilled her agreement. And now Ms. Holmes is again placed in fear. And that's all I have to say.
Thank you. All right, let's, anybody need a restroom break or anything? You ready to go?
Yes, sir.
Pardon me?
Judge, I think someone on the fence.
I need to go to.
Sure. We'll take a short recess.
I'd just like for the court to order this witness off the stand. I think the state has demonstrated that the only purpose for which they want that witness there is for the improper purpose, and they're compounding the prejudice by having her remain there. I think that unless the state has something that's admissible that they can prop to this court, that witness testimony needs to be concluded.
Thank you. State will speak.
Judge, the state's not.
Pardon?
There's additional information and things that's open to being talked about.
Thank you. So this is my thought, counsel. I don't have a problem declaring the witness to be hostile to state and allowing you to ask leading questions. I'm okay with that. I think that's been established. She's wearing an ankle monitor that was put on there by the state. I guess pursuant to this hearing where she was, I think you said she was in islands?
Yes, sir.
Regardless, so I would allow that. The problem I don't want to have happen, so we're clear, is I don't want you to regurgitate things that are in her statement that she's not, that doesn't comply with either of the two rules we've been going over. So I don't want you to be saying, well, didn't you say to, the police officer, Mr. Moretti, or whatever, the officer's name is Detective Moretti, that you saw them on FaceTime or whatever it was, that they were on that date when the incident in question happened, and Mr. Demons told you X, Y, and Z. All right? The witness hasn't subscribed that that statement was accurate, so it's not getting in under recorded recollection, and it's not getting in as impeachment because it's not. It's a police investigation, not a deposition testimony or something along those lines. So it doesn't get in the way I read the rule under either of those two sections.
So is your
So I don't
understanding-
want you to get in the back door, but you can't get in the front door.
No, just to make it clear, is Your Honor holding or stating that a police report cannot be used to impeach someone?
No,
Or-
I didn't
okay.
say that. What I said was the statement's in the police report, right? You can't just read that back to her. Didn't you say this to the police officer? I don't want that being done. I don't think that's appropriate. She says she doesn't remember the statement, doesn't know it's accurate. She didn't rely on its accuracy. And
Understood. And I just want to make sure it's also clear, under 9803 sub 5, the past recollections reported, there's no requirement in any of the case law or statute that the statement be sworn on that. If you look at that, because if there's other statements this witness has made that she may endorse as being truthful and accurate, and I'll have to ask her on that, then those are possibility of other ones that could be put in.
Your Honor, among the statements that we would like the court to forbid the state from asking in a leading fashion are the phone numbers or anything that she said to the officer on the day in question. What's the date that statement was made?
December 12th, 2018.
Nothing from that statement should be.
she'll ask whatever question she thinks appropriate. You make your objections, but I don't think it's appropriate to be asking, didn't you say this, X, Y, and Z. I don't think that's appropriate because she's not subscribing that this is what that statement is truthful, so I don't want you to just be regurgitating the statement and asking her that. I don't want that done, and I don't want you to do, anyway, we'll see where it goes.
Yeah, just one thing, Your Honor. I'm sorry to belabor the point, but I want to make sure that the state doesn't confuse the court's ruling to be one of form over substance, and instead of saying, didn't you say this, say, isn't it true that, or anything where the contents of that report are uttered out of her mouth that she knows this witness had not adopted, and she's going to get a no, and she's just putting it into the record. It's improper. And I've
Hopefully I
asked,
made myself clear, but that's why she's going to be able to, counsel's going to be able to ask ask whatever questions she deems appropriate. You make the appropriate objection if you think it's objectionable. I'm just going to rule. We're going to go forward like that. I don't know what you intend to ask, counsel. I just don't want it, the contents of that statement, regurgitation of that in some form of leading questions, all right? All right, bring the jury in. Let's get the witness back in. Come on up, Ms. Holmes. Thank you.
I'm sorry.
Jury entering.
Ladies and gentlemen, thank you. Please be seated. Let everyone once again reflect the presence for a jury that is part of the gentlemen, city council, the assistant attorneys, ladies and gentlemen, jury, and our witnesses home for you to understand. Apologize for the delay. Council, you ready to proceed?
Yes, Your Honor.
Please.
Okay, Ms. Holmes, when we left off, we were talking about a pet snake.
Yes,
Do you remember there being a pet snake?
I remember you talking to me about it yesterday.
Okay. And with regards to that snake, you recall it unfortunately passed away.
I'm pretty sure, probably, I'm not sure, it's not here, I'm pretty sure.
Okay. Do you remember the name of that pet snake?
No, I don't.
And in terms of the owners of that snake, do you remember who owned it?
I just know it was, I know who the owner was, it was in the house with Mariah lived.
Okay. Where did Mariah live at that time?
Should have been Myanmar.
And do you know the address?
No, I don't.
Who did she live with?
She lived with a boyfriend, but you know.
Okay. Are you telling the ladies and gentlemen of this jury that you don't remember your phone number in
I'm
October
telling you guys,
2018?
I do not remember my phone number. I don't remember.
And are you telling the ladies and gentlemen of this jury that you don't remember your daughter's phone number?
No, I do not remember my daughter's phone number.
And there's nothing that would refresh your memory or recollection whatsoever?
Objection,
That's
asked
4 years
and
ago.
answered.
Overruled.
That was 4 years ago. I've had so much trauma in my life since then.
Of course. So, is it fair to say that you were worried about Melly when you came down here to Fort Lauderdale on October 26, 2018?
Was I worried about him? Yes, I was.
You were worried about him because he had just been involved in a drive-by?
No, because they said his friends had been in the drive-by.
Okay. And you were worried about him because he was hiding in some bushes?
Objection.
I don't remember him being
Sustained.
bushes.
Okay. What do you remember?
I sustain the objection.
What do you remember?
I just remember him saying for us to come get him.
When you made contact with him later that same day at Frito's house,
Yeah.
is it fair to say he had no blood on him?
No, he didn't have any brother.
And is it fair to say that he left Frito's house and went up to a video shoot that afternoon evening?
Yes, he did.
Did you go to that video shoot?
No, I did.
Did Mariah live with Mr. Demons after the homicide for a period of time?
Yes, she did.
Did she live in a condo in Miami with him?
Yes, she did.
Okay. Have you made other statements about the events of October 26th of 2018?
I don't remember making any other statements.
Do you recall a Instagram conversation with the co-defendant Cortlen Henry?
I don't remember it.
Okay, if I may approach, I'll see if this refreshes your recollection as to that conversation. It's 3 pages.
Except for Mark, Counsel.
Not yet, Your Honor.
I don't remember it. I don't remember it.
You don't have any recollection of that?
I don't remember it.
Is that your Instagram, BlameQueen258?
Yes, it is.
Okay, and the conversation that you don't recall on that whatsoever?
Yeah, I don't remember it. No.
Okay. Is your testimony here today that you lied in those statements?
That I lied in my statements.
The allegations that you made to Mr. Henry?
I don't remember making those allegations, so I don't know.
Do you remember sending screenshots of those allegations to a detective?
I remember sending a detective something stating that I didn't threaten Bortlen.
No.
That's I remember that.
You remember sending screenshots of conversations?
I remember telling him that I did, because he reached out to me, asked me that I threatened to kill Bortlen. And I said, no, I did not threaten Bortlen.
Okay.
I remember that.
Was there any threats made to you by the defendant?
No, not at all.
In terms of your daughter, Mariah, where is she?
I don't know.
After this incident, did she live with the family of the defendant?
She's always lived down there. Before this incident, she always lived there.
And your testimony to the ladies and gentlemen of the jury here today that you saw Jamell Demons on October 26th of 2018.
I think I saw him.
That you spoke with him and heard him on the FaceTime conversation.
I did speak to him, yes.
And it's your testimony that he indicated that it was some sort of shooting that occurred.
Yes, I did, yes.
Okay, and it's your testimony that you saw him on your daughter's cell phone as a video call.
I saw him.
Is it your testimony today that after that you called Jane King?
Yes, I did call Jane.
And in terms of the conversation with Jamie King, that occurred immediately after the FaceTime?
probably not immediately, but sometime after. I'm not quite sure the time. I don't remember the time, what time it was.
Okay. And it's your testimony to the ladies and gentlemen of the jury today that you were dishonest in your first statement?
I don't remember my first statement.
Okay. Is it your testimony to the ladies and gentlemen of the jury that you would lie?
I don't remember my first statement. I have no reason to lie to you.
Yes or no? Did you lie to police?
I did not lie to you. No.
Yes or no? Did you lie to police?
I didn't lie to you. I don't remember my first statement. You're trying to make me say I remember my first statement. I didn't. For me to say no, I didn't lie with me. I remember my first statement. I don't remember it, so I don't remember.
Well, if you need more time to look it over, I have a copy of it.
I looked it over and I still don't remember it.
Okay. Well,
I did it over 100 times. I don't remember.
well, if you'd be so kind as to do it one more time.
Yeah, sure.
You can say that to this jury
I
that
don't
this
remember
is
that.
not truthful.
Yes.
Please.
Objection asked and answered 5 times, Judge.
Okay, objection noted. Over.
I honest to God do not remember any of this on here. Like, I don't remember talking, I don't remember, I had a hard time that year, so it's a lot that I don't remember about that year.
Is it your fun practice to lay law enforcement?
Objection.
Excuse me, can I
I'm
see
just
the
a lot.
Quiet, please.
So Ms. Holmes, is it the transcript that you're saying is a accurate version?
Sustained.
I don't know.
Excuse me, sustained the objection.
Okay, so going back to the relationship with your daughter and defendant,
Yes.
how long did that last?
3 years, not quite sure how.
Okay. During the course of that relationship, did she have multiple photographs of him?
I'm pretty sure she did.
Videos?
I'm pretty sure she did.
After this incident, on October 26, 2018, at Frito's house, is it your testimony that your daughter went upstairs with Mr. Demons?
She did. They did go upstairs.
They went upstairs. And do you know about what time you got to Broward County?
I probably got to Broward. Maybe I can't really remember the time. Maybe I don't know. I don't know. But 1 o'clock was after lunch because we went to right after. So it was after. It was lunchtime. It was 1 o'clock.
Do you remember going to lunch?
Yes.
Do you remember where you went to lunch?
I don't remember which restaurant.
Do you remember who you went with?
My daughter and AA.
And that's James Francois' wife?
Yes.
And do you remember your testimony to the jury that you remember the defendant, how he was dressed without blood on his clothing?
I don't remember what he had exactly what he had on, but I just remember that there was no blood because I would have been that would have freaked me out. So I know he didn't have any blood on.
No blood on him. Is it your testimony to this jury in terms of that you went to Frito Bang or Frederick Gibbons' house?
Yes.
Is it your testimony to the jury that there were other individuals present at that house?
Yes.
Who was it?
I don't know.
Do you recognize any of the individuals?
No, I don't.
Okay. Your daughter, she was present?
Yes, she was.
And in terms of your appearance here today,
Yes.
you don't want to be here.
Yeah, you're not going to do it. You made on here.
I did.
Yes, you
So,
did.
and in terms of you were served with a subpoena and
Never
prior-
served. You never served.
and so you were ordered by the court to show up.
You never served me originally. That was a lie.
And in terms of your job,
Yes.
did you quit your job?
I got fired because you put me in jail.
And prior to that,
Yes.
before you were put in jail, did you quit your job?
No.
Okay. So you never quit your job.
I had to leave because you told my lawyer to put a warrant out for me. So I had to leave my job.
Okay. So you left your job.
Yes.
Did the defendant ever offer to pay for you and your daughter?
No, I live my own way.
Have you ever made things contrary to that?
I don't remember.
So I may approach her?
Your Honor, objection.
Just show counsel.
Sure.
Can we approach?
Sure. Are you done with that?
Okay. Ms. Holmes, were you ever told the defense, or the defendant rather, would take care of you and pay for your bills?
No.
Have you ever made a statement that is different than that?
I've never said anything like that.
Can I approach her?
Sure. If you would just read this. I don't remember that.
Okay.
Getting money for my bills.
So, Ms. Holmes, is it your statement testimony that you never stated the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies? They didn't want us talking with prosecutors, but now they've all disappeared. You never said that before.
I don't remember saying anything like that.
Objection, Your Honor. Move mistrial.
Thank you. Why don't you come sidewalk?
Ms. Holmes, did you ever say the defendant made you quit your job?
I never really say anything like that. I know it's never made me quit my job.
Objection.
Overruled.
If I may approach her? I'm going to show you this next. Okay. So, Ms. Holmes, I'm going to ask you again. Have you ever made a statement that the defendant made you quit your job, that they would take care of us until the trial was over?
I don't
Objection.
really say anything like that.
Okay. So you're denying making that statement?
I don't really say anything like that.
Oh.
Objection. Your Honor, can I just have a standing
Yes.
objection so we don't keep interrupting?
Thank you. Any statements we heard on the standing objection?
Whatever defense is
That's
chooses to
fine. Go
proceed.
ahead.
Okay.
No.
So, Ms. Holmes, in terms of you made a statement to the effect of you were told to quit your job and the defense would take care of us.
Objection.
No.
Excuse me.
The defense? No.
Why don't you come
Never said
sidewalk?
anything like that.
And we have another motion.
Ladies and gentlemen, there was an objection made to the last question. I've made a determination that was an inappropriate, improper question, and the way it was phrased was totally improper, and therefore I sustain the objection. I am instructing you that you are to disregard the question. All right? I'm going to ask counsel to rephrase the question. Go ahead.
So it's clear. Ms. Holmes, did the defendant ever make you a promise to quit your job and that they had us?
Objection. Asked and answered.
Thank you. Overruled. Proceed.
I don't remember saying anything like that.
So your testimony is that you've never said that.
I
Objection.
just- I don't remember.
Excuse me, counsel, she answered the question, all right? Let's move on.
So with regards to your statements with Cortlen Henry. Do you remember speaking and talking about your daughter with Cortlen Henry?
No, I don't. When was that? I don't remember.
Sure. When was that? Here, I'll give it to you again. This was February 5th of 2021. Do you still have it?
Oh, no, I don't remember that.
You don't remember that?
Yeah.
Did you talk to Cortlen Henry about your daughter's involvement in this case?
No, not that I can recall.
Ms. Holmes, did your daughter tell you what happened in this case?
Objection.
No.
What's the objection?
Calls for hearsay. It's immaterial.
Not what the statement said, but did she say something about the case? It's overruled.
No,
Not
she
what
never
was
told me
said.
about-
Just,
she
did
never
you have
told
a,
me.
excuse me, not what was said, was there a conversation?
Was there a conversation that your daughter told you what happened in this case?
What do you mean what happened?
Did your daughter
No,
ever
she never
tell?
told me. She hasn't. I asked my daughter, did she know anything about this case? And she said no.
Have you ever made a statement different than that?
Not that I can recall. No, I don't remember saying anything like that.
May I approach her?
Yes, ma'am.
We object.
Why don't you show it to counsel first?
Sure.
Can we approach?
Yes.
Sorry.
Ladies and gentlemen, take a short recess. Don't discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence. Learning no research, just leave your notepads on your chairs. Want to come sidebar again, please? We're in recess. record reflect the approach to the defendant, his counsel, the assistant state attorneys. The jury's not here. They're in jury. We all ready to proceed?
Yes.
All right. See if they're here, please. See if they're ready.
Jury entering.
Ladies and gentlemen, thank you. Let the record reflect the presence of the defendant, his counsel, the assistant state attorneys. Ladies and gentlemen of the jury, our witness remains on the stand. Please be seated. And remind you, Ms. Holmes, you're still on the road. Counsel, please continue.
Let me let Ms. Holmes, I ask you, did your daughter tell you, did you have a conversation with your daughter about what happened on October 26th of 2018?
Yes, I asked her if she knew anything about that.
No. Did she tell you what happened without? No, she did
Just
not.
told she didn't know.
Have you ever made a statement that is different than that?
I don't know. I wouldn't know.
Your Honor, we'd object to lack of foundation, calls for hearsay, speculation, unless they can establish that that witness was present.
Thank you. The objection noted. That's what I previously ruled on sidebar. Proceed to your approach.
Showing you your messages from Instagram from February 5th of 2021.
Who was that Instagram? Is that the one the Instagram stands with Bortlen?
Ma'am,
I don't
sorry.
remember. I don't remember that Instagram.
Look at it.
I already looked at it. You want to show it to me?
So is the...
I don't remember that. You showed it to me like 3 times already.
So you don't recall making
I don't
a
recall
statement
making that
from...
statement. No.
Excuse me, one at a time, please. Let her finish her answer before you ask the next question.
So you don't recall making that statement?
No, I don't.
So you don't recall saying...
Objection.
Sustained.
So, Ms. Holmes, in terms, you said that your daughter didn't tell you.
Objection. Asked and answered.
Sustained.
So did you ever make a statement that's different than that?
Objection. Asked and answered.
Sustained.
Into the statements that, with regards to October 26th of 2018. Is it your testimony to the jury that you remember coming to Fort Lauderdale?
Objection, asked and answered.
Sustained. Listen, I just want one of you making objections. Whoever's going to handle those
Yes, sir.
witnesses. All right?
I apologize.
Ms. Holmes, is it your testimony you don't remember why you came down?
I told you why I came down.
Okay, why is that?
Objection. Asked and answered.
Sustained.
Ms. Holmes, have you ever... Let me rephrase. Ms. Holmes, did your daughter ever threaten to cooperate with law enforcement?
Objection.
Sustained.
Ms. Holmes, did you threaten to cooperate with law enforcement?
Objection. Asked and answered.
Different question.
Why don't you come sidebar? I want to see the question, please.
about what happened on October 26th of 2018.
Objection. Asked and answered.
I don't know what statement you're talking about. Rephrase the question to a specific.
Ms. Holmes, did you ever make any statements specific to what was happening in the car on October 26th of 2018 prior to the homicide?
Objection.
Thank you. I still come on sidebar, please.
So, Ms. Holmes, I want to ask, were you present when your daughter spoke with law enforcement?
She was 17, I had been present.
Do you recall about when that happened?
If she was 17, that had to happen in 2018.
Okay. Without getting into what she said on that. Do you remember where that statement was taken?
No, I don't.
When you came down to Fort Lauderdale, was your daughter concerned for Mr. Dennis?
Objection. Cause for conclusion on part of this witness.
Based on your daughter's demeanor,
She was
how was she
Objection.
acting?
Sustained.
When you arrived in Fort Lauderdale and saw Mr. Demons, did you ask him what happened?
Objection.
What's
Asked
the
and
objection?
answered.
Overruled.
I'm sorry, repeat the question?
When you arrived in Fort Lauderdale, did you ask Mr. Demons what had happened?
No, I did not.
Nothing further.
I have one question.
Yes, sir.
You came here and one of your first, let me get it.
Objection, Your Honor, improper.
I haven't asked you.
Excuse me, Counsel, you direct your comments to.
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first took the stand, you said, I feel threatened.
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
Overruled.
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
Anything else to this witness?
Yes, Your Honor. Ms. Holmes?
Yes.
You said you feel threatened by me.
Of course.
Okay. Did you fail to appear for numerous court appearances?
No, you never served me. You lied.
Okay.
You lied to the court.
And with regards to, did you work in Redding, California?
Yes, I did.
Okay.
Immaterial.
Overruled.
And so that was a location you were at?
That's why I was traveling nurse. Yes.
Okay. And in terms of the prosecution, you have been served on various occasions to testify.
You served me a subpoena on November to be the next week, and I was in California, 10 hours away. It wasn't even served correctly.
And prior to that, you were served with a subpoena in
Never.
February of 2019.
You never served me. You served it to a location I didn't live at anymore.
Do you recall coming to the courthouse in February of 2019?
Objection beyond the scope.
Excuse me.
Anything about the courthouse in
Excuse me. Come
2019.
sidebar, please.
So, Ms. Holmes, you even went so far as to hire an attorney
Yes,
to
I
try
did.
not to show up.
I sure did.
And has the state offered you any money?
The state basically has me on a monitor. I have to go to my job with this. It's embarrassing. People think I'm a criminal. The state has run my life.
And in terms of your feelings and ill will towards the state and myself,
I just feel like you lock up innocent people.
and does that influence your testimony today?
It's not influencing my testimony.
Have
No,
you-
I'm telling you,
Have you-
I'm-
that's not-
I don't
that's
know.
not-
Excuse me, hold on. Only one of you can talk at a time. You ask the question, counsel, you answer it, and when you let her finish her question, and then when she starts answering the question, you let the witness answer her question, all right?
Yes, Your Honor. So that my question was non-responsive on that one.
Ask your question.
So, Ms. Holmes, in terms of the court order that was issued,
Yes.
you're aware that that was found to be valid?
No, I'm not aware of that at all.
Okay. You hired an attorney to go and represent you at the Fourth District Court of Appeals?
He had to hire an attorney because he tried to get him this far.
And no, that's a false statement.
Objection.
That-
Excuse me. Counsel, you're not testifying.
I
all right?
agree on
You
that.
Excuse me, you asked a question, all right? That's it, you asked the question.
And so, Ms. Holmes, with regards to that, you hired an attorney,
Yes.
and you then tried to get any sort of court order requiring you to be here in court thrown out.
No, what I did was I hired an attorney because you were saying you served me the subpoena that you never served.
And that was found to be valid.
You never served me a subpoena that was never, you never served me.
Oh.
I've never seen a subpoena from you with those addresses that you said you served. Those
So-
are not my addresses.
Your testimony is that you have never been served to appear in court.
Objection,
I've
asked
served,
and
I've never
answered.
did.
Sustain, excuse me, sustain.
And so, with regards to your feeling threatened on that, have I ever any sort of physical violence against you?
No,
Okay. Do you have any written threats from me?
it's intimidating. You've intimidated me this whole time. As of
And,
now.
and in terms of your participation in this case,
Yes.
you understand that you were served a subpoena to appear here today?
You served a subpoena after you arrested me. You
And
served
you,
a subpoena at the jail when I was in Brown County.
and you understand you were here pursuant to that court order?
I'm here.
And that requires, under the law, to comply with court orders to, and that compel attendance of witnesses.
I've been complying.
Okay. Nothing further, Your Honor.
Anything further?
No, sir.
Thank you. This witness excused?
Yes, Your Honor.
Thank you, ma'am. You may step down, you're excused. Want to come sidebar here, please?
Sure.
Ladies and gentlemen, I was just checking with counsel, that's all the evidence we have for today. So my thought is, remember the admonition, we'll see you back on Monday though, 9 o'clock. Remember, do not discuss the case. Tuesday, that's right, Monday's a holiday, thank you. So Tuesday at 9, don't discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence, certainly no research, all right? Same admonition I give you every time we break. We're counting on you to follow it. All right, just leave your notepad on your chair. We'll see you back on Tuesday, 9 a.m. Thank you. What did that? Let the record reflect the jury stepped out. Counsel remain along with the defendant and the assistant state attorney. Ms. Bradley, my clerk is advising me that I don't know if it was, I don't think there was any evidence that she had something that might have been marked as an exhibit.
It was not marked, Your Honor, it was just a copy of the
So
transcript.
you're okay with it?
Yes, Your Honor, I have plenty of copies.
All right. In any event, so jury's been excused, counsel remain along with the defense, so you have a couple motions from this trial. You want to talk about those?
Yes, sir. as sure as I could predict that Tuesday comes after Monday, I made sure to stay up till 2 o'clock last night to get these cases, to alert the court to what was the state's obvious intention. To put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible, instead of at least admitting that that was what the state intended to do, it advanced a ruse pretext that they were seeking to do so under 8035. It turns out that 8035, given the witness's testimony, could not be employed. And so the state then went back to Plan 1, the original one all along, of the state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had, into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done, and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise. That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state essentially tried to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the back door, but you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Demons has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate, it is highly prejudicial, this jury has been tainted, and we move for a mistrial. Oh, there's one more thing. If you don't mind, I'll have Mr. Alistine articulate what that might be.
This is your motion for mistrial, Mr. Addison?
Yes, it's our motion for mistrial.
This is the second one. All right, go ahead.
Well, it's second one. Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness. And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this, is so improper. Not only does it taint our client on the other questions, but it taints everybody at this table. And despite the judge, Your Honor's instruction to ignore it, it's pretty hard to ignore something like that. When their entire questioning for the last 30, 40 minutes have been so improper, and the court told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh or spoken to her twice ever at that deposition and today. Never by phone, never by text. Couldn't distinguish her from a can of paint until she showed up for the depot, and I haven't spoken to her since. So just to let the court know, there is no factual predicate for the implication, or not implication, the accusation made by the state that the defense sought to take care of her.
And the same for me. I met her at the depot and saw her today.
For the record, it was my first time ever seeing her in my life.
Thank you. All done, guys? Counsel?
Yes.
Yes, madam?
Judge, with regards to that, the statements that were in the records are what was used as impeachment, where it says they said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form. So defense implied or read into that in some additional context that was not intended in any way, shape, or form. I was basing it on based in the records and the statements that this witness made and put forth in her Instagram account about this case on that. And it's very, in terms of the forming the questions, Your Honor, it was understood that I was put under very strict and difficult conditions to formulate any question, because defense obviously wants to limit, because they know the contents of what this individual has said and all of the statements that she has made that are damaging to their client. Hence why the state would be seeking to use her as a witness.
That means nothing, Your Honor. The fact that it's damaging, I'll concede that. It's inadmissible. And the status of this impression that there is a catch-all, we're only trying to seek justice and do good, exception to all the rules of evidence. And there is no such thing. If it's admissible, admit it through an admissible procedure. You don't try and end around the court's order and the case law by coming in on some pretext and doing exactly what I told the court would happen and create an entire prejudicial fiasco and introduce inadmissible evidence into the record. That's what occurred, and this jury has been irreparably prejudiced. Or Mr. Demons' interests have been irreparably prejudiced before this jury.
Thank you. In any event, I'm going to defer ruling, take it under advisement. We'll see everybody back on Tuesday. I suggest that you talk with your client, discuss with Mr. Demons whether or not his feelings about motion for mistrial. I think it would be appropriate that he be consulted as well. But I haven't reached any conclusion about it, and so I'm going to see exactly what was said. I thought I heard what was said, and I'll check with the court reporter, get a little piece of that transcript, and we'll go from there. And I'll take it under advisement. But you talk with your client about it. We'll see everybody back on Tuesday. All right,
Yes, sir. Have a good weekend, sir.
Judge, since we're breaking early today, can we have a few minutes with our client? Right
Sure,
now?
I'd like you to take a few minutes with him. I'd like you to talk it over with him.
Yes, sir.
Can we have the cameras off while we talk about
I
it?
can't hear you.
The camera's off.
Oh, you want privacy, that's fine. The cameras can be excused. They can go out of the courtroom.
Thank you.
Everybody can go out of the courtroom. All right?
Thank you so much.
Thank you.
Adjourn. This is like a private conference area.
Thank you.